Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. This one's going to be kind of quick because I got to go play some pickleball, because pickleball is what old men do in 2025. We have a question here from YouTube user Delivery, maybe a play on words for delivery, I'm not sure, 14927, who says, would it be useful for a plaintiff in a discrimination and retaliation case to use their predecessor, who was also set up by the same supervisor and fired? On her first day on the job, plaintiff found copies of the emails and texts showing the setup tactics and plain, mean, and vicious language used towards the predecessor. They were obviously left on purpose for the replacement to find. The thing is, the predecessor does not appear to be in a protected class. Would such a witness be useful in this case, or have the opposite effect, since they likely did not have any protections? Yeah, so listen, if that person shares your protected class, which you note they do not, then that is entirely useful and you could show a pattern. Here, though, you're essentially applying a defense. You're supplying, I should say, a defense for the employer, because essentially the argument is, hey, yeah, I'm not discriminating. I'm just a bad person. And believe it or not, that is a tremendously good defense in this field. Remember, it's legal to be a bad person. It's legal to be incompetent. It's legal to be mean. It's legal to be a terrible boss. All these things are legal. What's not legal is to discriminate in the workplace, to sexually harass in the workplace, to retaliate tied to some protected activity in the workplace, but to just show that your manager has a tendency to be awful. You're making their argument for them, right? Essentially, the argument goes like this. Oh, yeah. I was not discriminating. I'm just the worst. But I'm the worst to everybody, right? And that's a classic joke. There's tons of stand-up comedians who are like, I have a friend who's a stand-up comedian. And I think his joke goes like this. Realized the other day I'm the most racist person I know. Shouldn't probably deliver his joke, but that's how the joke starts. I realized I'm the most racist person I know. And then the punchline is, because I hate all the races. I hate everyone. That's terrible delivery of his joke, but you get the gist, right? Slightly different version of that, which is the defense here is, yeah, this is not related to a protected class. I'm just a bad person. I do bad things. Like I'm an active monster engaged in hateful conduct towards everyone. It's the devil wears Prada argument, right? Like, in many ways, like, yeah, it's not discrimination. I'm just the worst. That is a tremendously effective defense in this field for employers, defendants who are willing to use it. And it comes out more often than you would think because people don't want to pay hundreds of thousands, if not millions of dollars in a settlement or a judgment. So they're willing to just cop to the reality of the situation, which is they're bad. They're bad people. So delivery. I hope this answers your question, gives you some context. I hope you don't fall into that little bit of a pit trap there, because it sounds like you got a viable claim potentially. We don't know the details, obviously, so I can't speak to that, but I wish you great success. And if this was helpful, like, subscribe, comment down below, share the channel so it may grow. Take care, everyone.